Welcome to EPG Pathshala. This paper is the philosophy of law. The module is state versus non-state law. The objectives of this module are to understand the multitude of non-state legal practices in India from the vantage point of legal anthropology. This module was written by Mikhail Dusha from the Manipal Center for Philosophy and Humanities. I'm Akash Singh Rathore from Lewis University of Rome. So let's begin. This module raises questions about the status of traditional, customary, and contemporary informal legal practices in the context of the modern Indian state. From a modern perspective, informal legal practices have no legitimate status. They're rendered invisible by the conventional stage theory of the genesis of modern society, or otherwise they're regarded as remnants of a bygone age to be done away with once modernity has taken full shape. So societies with such apparent non-synchronies means operating state law and non-state law at the same time, are usually regarded as developing societies, that is, those that have not yet fully arrived into modernity and that are always in danger of falling behind the normalized standards of Western modernity. Legal and political philosophers, philosophers of history, and more general, historians of philosophy have experienced or encountered this sequential staging of history most precisely in Hegel's conception of the philosophy of history and its recapitulation in his conception of the history of philosophy. The ideas behind Hegel's philosophy of history serve to give a moral backdrop for the dominance of modern rational state law. In other words, if we see modern state law as actually disenfranchising the population, disenfranchising the common man at first before returning the ability to acknowledge the free, equal dignity of each person, then how do we justify this process of first violating all norms of justice, violating all sense of equality and dignity, before hundreds of years later returning that to the people? So Hegel's philosophy of history, which was taken in almost full form by Marx in his own conceptions of the evolution of communism after the collapse of capitalism, served as the moral ground for this sequential staging. So what is this sequential staging idea? This view actually dominates policy and development discourses all over the world. It's also quite prominent in political philosophy, as much as particular legal theorists or political theorists deny that they adhere to it. It holds that a fully modern society contains no remnants of its foregoing stages. So you might remember this from Hegel's philosophy of history or Marx's representation of history. That is, it is a received narrative of progress in modernity, a fixed sequence of stages to be lived through by any society or culture in order to arrive into the now of modernity. The kind of stages we're talking about are tribal or lineage societies, tributary societies under chiefs or kings, and then as we progress forward, pre-modern monarchical or imperial state formations, until finally we reach the early modern state. Well, this narrative hardly holds true even for the West, from whence it originated, but it definitely holds far less true for other parts of the world. Non-European societies never experienced Europe's deeply disturbing events, such as the decades of religious civil war, which saw up to 2/3 of certain populations in Europe perish and disappear due to armed conflict, due to starvation, due to plague. This was an experience unique to Europe and led largely to this idea of narrative or staged progress in history. India in particular never experienced these sorts of Enlightenment events or large-scale starvation, plague, and conflict that would push it into a new understanding of the nature of law and the need for political stability. So within India, what we find are different types of legal practices: traditional and modern, customary and constitutional, differential and unified, that all run in parallel, none of them completely overtaking the other. In other words, we have practices synchronistically of state and non-state law. Well, there are merits and demerits to both state and non-state law. For example, modern state-sponsored law never managed to prevent Europe from committing the highest atrocities, even giving legal backing for those atrocities. Think of the death camps during the Nazi regime in World War II. Think of the bombing of Hiroshima and Nagasaki by the American army. All of these things had legal cover and were performed by the modern legal state. Likewise, traditional and modern legal practices in India have also allowed atrocities. Of course, not on that grand scale like an atomic bomb or regime of death camps. But nevertheless, we know that discriminated genders, discriminated castes, and communities are allowed to be treated as unequal without the objection of either traditional or customary law or even modern state law standing in the way. So while vulnerable communities, vulnerable minorities within India set great hopes on the egalitarian and emancipatory nature of modern law, the actual practices on the ground of bracketing constitutional equality for Dalits and Adivasis and so on has led many legal theorists and political philosophers to dismiss modern state law altogether. You can think of Ashish Nandi as a paradigm in this respect. So let's talk about state law in terms of its historical origination and the consequences of its practices. With modernity taking shape in Europe, the departure from pre-modern and non-state legal practices was quite decisive. The medieval Christian order broke down with the religious wars of the 16th and 17th century, and this decay was further catalyzed by the Enlightenment philosophies, the rationalistic Enlightenment philosophies that came thereafter. Christian natural law gave way to a rational-based natural law. In some respects, reason supplanted the place of God in the European mind. Liberal contract theories, you can think of Hobbes, Locke, Rousseau, opened the space for new ideas of the social, which are not grounded in God. Rather, they are grounded in rational statecraft and individual liberty. So modern law thereby created the ethically neutral space where capitalism could flourish. It also created a space where the state could emerge as an independent force, disconnected from the divine, disconnected from religious obligation, and the state could develop reasons of its own, a rationality of its own. Think of the concept of raison d'etat, which is so common in global politics, international relations. What it suggests are reasons of state. So the state has its own autonomous existence and its own reasons, grounded in its own rationality. This increasingly absolute state was buttressed or supported as well as criticized by the philosophy of the Enlightenment. It was also seen as an imposition on the people, on the ordinary people, by the state apparatus, elites, monarchs, subsequently noblemen and bureaucrats. That means that, contrary to how we usually see it, that the modern state has been hegemonic and imperial outside of Europe, legal anthropologists actually believe that the modern state was also imperial and colonizing, self-colonizing within Europe. It was imperial at home and abroad. So this imposition of modern law and the state as an absolute state was perceived as a disenfranchisement by the common people, not only abroad through the colonies, but in Europe itself. It took several hundred years for common people to be re-enfranchised into the new organization of the modern democratic state. In a more quotidian perspective, however, resistance to the state and state-administered law can also be seen as an indicator of a thriving life world that resists attempts at colonization by the modern state. So, according to this view, if you understand the functions of implementing modern law absolutely through the modern nation state as in some way a colonization of the life world, then you can see contrariwise that when there are thriving alternatives to modern state law within the life world, you can see it as a vibrant attempt to push back. So now let's turn to India and see how India's life worlds still retain an astounding capacity for self-organization outside of the paradigm of state law. Before turning to India, let's summarize some of the ideas behind the idea of state law. So within state law, what we find is a comprehensive legal system that's supposed to be based on rational order and demands universal obligation and participation by every single member of society. Each member of society is seen as rational, as equal, and as subject to the law in his autonomous capacity. You can see that this is somewhat ideal and abstract because actual practices differ very widely. And indeed, on the European continent itself, where this idea of modern state law occurred, there were numerous plural legal practices vying for dominance in particular regions. The regime of modern state law came and started to push out all of the plural practices and established its absolute regime. And this is what we referred to by the colonization of the life world by modern state law. This is interesting because India resists this to a very large extent even today. In much of the post-colonial world, self-governing communities still exist outside of the purview of the modern state. So while India as a modern liberal democratic state attempts to colonize all of these life worlds through the rational order and organization of constitutional law, administrative law, civil law, and so on, what we find are that there are innumerable pockets of self-governing communities that resist or that ignore this sort of state law imposed from above, or contrariwise, you can think of the areas where the Nakshals are very active, where state law has simply refused to reach or has not yet reached. In these places, there are a number of self-governing organizations in a way that we can't call democratic by modern standards. But as the philosopher of law and political philosopher Jürgen Habermas has stated, every social interaction that comes about without the exercise of manifest violence can be understood as a solution to the problem of coordinated human action. In other words, as long as there's not manifest violence, then these kinds of organizations, while we might not call them democratic according to the modern conception, are viable ways of organizing communities. Now, the prima facie legitimacy of such systems of social norms should not be overestimated. In this respect, you can think of Dr. Ambedkar's critique of village collectivities as sinks of localism and largely oppressive. However, they should not be dismissed out of hand as merely pre-modern legacies that must be overcome. And in this respect, you can think, on the contrary, of Gandhi's conception of village organization as being ideal and far superior to succumbing to the organization of modern rational state law. Well, what does legal anthropology tell us about these organizations within the Indian context that both interplay with state law, that operate outside of state law and that in some cases substitute state law. We learn from legal anthropology that there are many types of societies that are organized around non-state legal practices. These are caste and village societies, rural and urban communities. Some are traditional, some are modern. What marks their practice as fundamentally different from modern legal practice? This is a question that legal anthropologists have been asked by philosophers of law. So we've documented a lot of cases of the practices of non-state law, but philosophers of law want to understand what is it that makes them precisely different from modern legal practice. One answer has been given. It's not a universal one, and it's not even a majoritarian one, but it does touch on a certain aspect that's important. It's the reluctance, according to these practices, to take punishment into human hands. So you can think of Gandhi saying that we should leave punishment to God. Legal anthropologists have noted this in a number of communities that self-organize in resistance to state law. It's the marked character of state law to remove punishment from the hand of God and put it into the hand of the sovereign. So in the transition to the development of modern legal practices in Europe, one of the crucial moments of this was removing the concept of crime from the concept of sin. In other words, criminality was considered a transgression against human legal norms and should be avenged through human legal norms. Well, if we have such an alternative conception of criminality and punishment, we obviously have an alternative conception of law as such. So how can we even begin to define non-state law in a manner that is consistent with definitions of the law? Upendra Bakshi, one of the great legal philosophers of India, has given a definition of law that resembles that of Max Weber's definition of state law. I quote Bakshi: "An order will be called law if it is externally guaranteed by the probability that physical or psychological coercion will be applied by a staff of people in order to bring about compliance or avenge violation." So there are some key points to notice here. There is coercion to conform. That coercion can be either physical or psychological, and it should be applied not by one person, but by a staff of people. In other words, there should be designated people within the community who are regarded as those who would enforce that coercion to conform to the what we call law, normally is called customary practices. A certain legal anthropologist named Herbal has, in a book from the 1950s called The Law of Primitive Man, attempted to give another definition. Herbal states, a social norm is legal. So just keep that in mind. A social norm is legal if its neglect is regularly met in threat or in fact by the application of physical force by an individual or group possessing the socially recognized privilege of so acting. So Herbal allows for an individual to take charge of the punishment. However, the key point is that that individual should nevertheless be socially recognized as having that privilege. Now, if we take these to be the meaning of law, then legal anthropologists have recorded and documented numerous cases of the sustained practice of non-state law throughout India, and this also refers to post-modern, post-constitution, post-independent India. Let's see some examples of non-state regimes. Legal anthropologists have presented many through particular studies, and I'm going to list a few of them. Martin Bavinck gives an interesting account of how different legal systems interact in the case of legal regimes governing trawler fishers, so the fishermen that are out at sea, beach-based fishers, and then Tamil Nadu's state laws. So what we find here is a strange interaction between customary practices from particular communities, because the trawler fishers belong to one community, the beach-based fishers belong to another community. Both of those communities exist within modern Tamil Nadu, which of course has a number of state regulations about how fishing can be done, who has rights to certain areas, and so on. Now, the anthropologist has shown us that far from the legal code of Tamil Nadu state regulating fishing, these communities self-organize and have developed their own customary practices, which are elevated to the standard of law. How so? Just as we had spoken of the definitions of law, if these customary practices, not Tamil Nadu state laws, are violated, then the communities will get together, punishment will be meted out. This punishment will not be meted out according to the dictates of criminal law in Tamil Nadu, but rather according to traditional non-state practices of these communities. So here's a perfect example of the synchrony of state law and non-state law governing concrete active communities in India to this day. Marie Karen has shown how authority is held accountable and justice is dispensed through the kolas of coastal Karnataka. So, analogous to the earlier example, you have Karnataka's municipal laws, you have the laws that the state enforces, but legal anthropologists on the ground show that the kolas have their own conception of the law. In other words, their own conception of customary practices, which, by any definition of law, must qualify as law. They're coerced upon the participants of that community. Certain people are designated to pursue that punishment, and so on. Peter Klaus shows how the local matrilineal system is held in place by the city cult. Now, the matrilineal system is not adopted into state law, and yet the city cult maintains that matrilineal system, and the consequences of that must be that, for example, rights of inheritance, rights of property, which are identified by the state as being contractually based, no longer patrilineal, of course, are nevertheless resisted by the members of this community, and an alternative matrilineal designation is enforced. Michael Dusha himself has shown how non-state legal practices actually subvert the very staff of state courts. In other words, this exercise has shown that while state law is most fully enacted by the staff of state courts, interestingly, the communities from which the staff of these state courts arise have their own local customs, and these customs subvert the practice of state law in the very site of the practice of state law, which are the courts of law in the modern state. Aditya Malik has shown how the shrine in a Himalayan village functions as a court of justice. This is a very common occurrence throughout India, in the northeast. Many sociologists and anthropologists have written about how temple justice and shrines are micro courts meting out justice, and in that sense subverting or supplanting the universality of state law. Anand Taneja shows how in Firoz Shah Kotla, petitions deposited to jinn saints keep medieval ideas of justice alive. So we've suggested that state law and its domination is pegged to a conception of supplanting older forms of law in history, and that we relegate these older practices to some sort of pre-modern or medieval period, and that maintaining these medieval practices destabilize the conception that a country like India has fully entered into the modern. What Taneja has shown is that many ideas of medieval justice are alive today in the customary practices of specific communities. So let's sum up. We have to keep in mind that, especially since 1991, India has been globalizing at an increasingly rapid speed. There are international and transnational non-state legal norms. Now understand this, that from the point of view of the state, transnational and international law is non-state law. It's another kind of law altogether. And this manner of non-state law, international transnational law, regulates copyright in India, trade, security, migration, human rights, and environmental issues. So this manner of non-state law also has to be taken into account. On the other hand, these are non-state laws insofar as they transcend any particular state, but they function according to the same logic of state law. That is, as we've shown in this module, such laws have the marked tendency to colonize the life world. Will India's traditions of non-state law, its indigenous traditions of non-state law, and legal pluralism be able to resist this new form of the colonization of the life world by transnational non-state law? This remains an open question. Thank you.